Good afternoon. Welcome to today's welcome to the last module of the day, which is business law, and we look at registration of business and compliance requirements. I'll be your facilitator for this. Okay, I'll be your facilitator for this module. My name is Fumi Johanna, as seen on the platform. So the objective of today's model, the objectives are: one, for participants to have a basic understanding of the nature of the legal system in Nigeria, to enable participants understand the legal regime and regulatory agencies regulating businesses in Nigeria, for participants to know the types of business organizations and steps in the formation and registration of businesses in Nigeria, and understand the basic nature and elements in a commercial contract. What are the topics we are going to look at? First of all, start by looking at the Nigerian legal system, the relevant government agencies regulating businesses in Nigeria, types of business organizations and legal implication of the various types of business organizations, registration of business organizations, law of contract. So let's quickly have a rundown of what the Nigerian legal system is. Before when we say Nigerian legal system, we're talking about the totality of laws and rules and regulations that are found within Nigeria as a sovereign state. So when you bring the constitution, the criminal code, the penal code, the uh, Companies and Allied Matters Act, the Finance Act, the EFCC Act, all we are talking about all the laws obtainable in Nigeria, be it federal, be it state, be it local government bylaws. Then we're also referring to the mechanisms that are put in place for the purpose of ensuring the implementation and making of such laws. So when we talk of Nigerian legal system, we're looking at the laws, we are looking at the bodies that are responsible for making such laws. So so when we say every time you hear the the you hear the phrase Nigerian legal system, just have it in mind that okay, they are referring to the laws and the mechanisms that are put in place responsible for the making and implementation of such laws. So, having said that, let's, what's law? I know so many people have many ideas of what law is. Law, we have different laws from our family to our communities uh, to state and national level. We have laws, and these laws are there to regulate conduct of person within a particular settings. So, but for the purpose of this class and for the law profession, we'll be more interested in the narrow and guided meaning of law as a rule of human conduct, tacitly or formally accepted by people as binding and backed up by some mechanism for the sustenance of its binding nature. So you see, for the purpose of this module, and will adopt the meaning of law as to what it is to the law profession. So it's more like a narrow and guarded, it's more like a human conduct, as a rule of human conduct. That's tacitly or formally accepted by people as binding. So that's one of future of law that is very important. For law to be acceptable in a society, it must be one binding and backed up by some sort of mechanism. What are those mechanisms? One, the people must accept it as binding, then it must be backed up by some sort of mechanisms. That's why we have institutions in Nigeria that are put in place to ensure that laws are obeyed. We have the courts, we have the police, we have other security agencies that are there for the purpose of implementing and sustaining such laws. So let's look at, and they are there for the purpose of ensuring that the law is binding on everybody. So what are the sources of the Nigerian laws? So let's quickly look at the sources of Nigerian laws. We have the English Receipt Law, which is the combination of common law and doctrine of equity. Then we also have the statutes of general applications. These three uh, sources combined together form the English Receipt Law. So when we say English Receipt Law, when the British came to Nigeria back then, they came with these laws and we imbibed them and made it ours. That's why they are referred to as English Receipt Laws. For instance, the common law was brought in by the British to Nigeria, and they began implementing it in Nigeria, and it became part and parcel of our laws. So let's look at how the history. Let's look at the history of common law, how it began in England back then. So back then in England, they had nothing called common law. There was no unified system of law. Every society or every locality in England was just administering justice based on their custom and tradition. However, after the Norman conquest and subsequent enthronement of King William, the first, I guess, the he began sending out itinerant justices. Itinerant justices, that means justices that move from one place to another. They are not located in a single place. They move from one place to another for the purpose of administering justice. So if they go to a particular locality, they will administer justice based on the custom and traditions of that locality. Eventually, after they are done for the day, they will meet at the crown. So all these itinerant justices will come and sit down at Westminster back then they will come and discuss the various customs they've encountered. So if a custom is very good to solve a problem, then they will agree among themselves that okay, if I go to community A, if I encounter a similar problem, I am going to use I'm going to use the custom of community B to solve the problem in community A because the custom of community B is more suitable for solving such solution. So as a result, there evolved what is called a common law. So common law can be defined as law that was formulated, developed, and administered by the old common law courts of England. You get it? So as a result of the evolution of common law, then came about the common law courts in England, which were established for the purpose of administering common law. So eventually, common law became more rigid and became more concerned with procedures and form. So what if I say it became rigid and became more concerned with procedure and form? What I'm saying is that, for instance, you want to institute a matter at common law court, then the law says if this matter that has to do with theft, the law said you have to write down your complaint in yellow paper. It's just an example I'm giving you to get how common law became rigid, because that will set the background for me to talk about doctrine of equity. So if the law says if matters concerning theft should be on a yellow paper and you decide to write it on a green paper, the court will not entertain your suit because the law says it must be on a yellow paper. So that made the administration of justice to become more rigid, and eventually people became dissatisfied with the judgment they are getting from common law, and they are unable to administer, okay, to obtain remedy. If you obtain justice against an influential person, for you to enforce that judgment became difficult. So over time, people began petitioning the crown. So they will petition the king that, okay, or the queen, depending on who was on the throne at the time. So they will petition the king or the queen that, look at what common law did. I have a good case, but because I failed to do this and that, they don't want to entertain my matter. So they became more concerned with form and procedure. So if they petition the crown, the king's council are there to entertain the matter. And the king's council comprises of the chancellor then, who had a priestly background, and he used that background to adjudicate on matters. So if litigants are dissatisfied with the judgment or the procedure, or with the judgment they got at common law court, they will petition the crown. So that eventually resulted in the development of doctrine of equity. So when we say doctrine of equity and equity, what I meant here is not equity in the common palace, like in the as fairness. Rather, equity is a part of England law that was developed by the Court of Chancery for the purpose of mitigating the harshness of common law. Because common law was very harsh with respect to procedure, that if you fail to to follow the procedure stated by the law, common law will not entertain your suit. So as a result, evolves doctrine of equity. So from common law, they have two courts now if you are dissatisfied. So there was conflict between common law and doctrine of equity, but we don't have to go deep into that. Eventually, this common law doctrine of equity, statute of general application, were all brought into Nigeria by the British when they came to colonize Nigeria. And these laws are applicable in Nigeria presently. For examples like doctrines of equity, we still use the maxims like he who comes to equity must come with clean hands. He who seeks equity must do equity. So many other maxims that are quite popular and are used by every day. Almost everyone uses such maxims to justify one thing or the other. So another source aside the common law doctrine of equity that I just discussed, uh, which I refer to as received English law, together with the statute of general application, we have the Nigerian legislation. I know this one is quite popular. We know we have the National Assembly at the national level. We have the uh, State House of Assembly at the state level, and this are responsible for making laws. So you know the procedure for making laws. It will be introduced as a bill. There will be first reading, second reading, then there will be the bill will be referred to committees where they will deliberate upon. Then there will be third reading of the bill. Then I guess there will be voting. After they voted, then it will be passed into law, it's assented to by the president. So once it has been assented to by the president, at the national level, they say it becomes an act, while at the state level, they say it becomes a law. So we have so many laws that have been enacted by the legislation, like our penal code, criminal code, the Companies and Allied Matters Act of 2020, the Finance Act of 2020. So the laws are just many. All the laws establishing the federal universities in Nigeria are all went through legislation at the National Assembly. That's why they all have their acts. So these are examples of uh, Nigerian legislation sources, and it's also a source of Nigerian law. So we have customary law. Customary law basically, is whereby customs of the people is used, or the customs of the people are used to adjudicate on matters matters or conflicts that might arise in that particular community. So they will use their own custom, just like the common law. Our customary law, the common law in England too is like a customary law. The only difference is that theirs is codified, ours is not codified. So we have our customary law that are still applicable. Even if you go to court now, the conventional court, it must not be customary court. If you go to courts of superior record like the Court of Appeal, High Court, and the Supreme Court, our customary courts are still applicable. I love to use the Benin customary law of inheritance because that custom is so notorious that any matter or anything that has to do with um, the Benin customary law of inheritance, once it has to do with properties, the fact that where the father was residing before he died always belongs to the first male child. That is not in dispute as far as the Benin customary law is concerned. It's the first child that will inherit, and there have been a number of cases at the Supreme Court that the Supreme Court have decided that once it comes to Benin customary law and it has to do with inheritance of property the father was residing in before his death, that belongs to his first male child. So all other courts in Nigeria are bound by that decision of Supreme Court. So if any matter of similar nature arises, and the parties go to court and it has to do with inheritance, it's certain that it belongs, as far as it's Benin customary law, there is no dispute as to the fact that it's the first male child that will inherit that property. Then there are other customs too that are applicable, but I just use that Benin customary law because it's quite common and notorious. Then we have judicial precedent and case law. We have different arms of government. We have the executive, we have the legislative arm of government, and we have the judiciary. So the judiciary, as you know, are responsible for interpreting the laws. So in the course of interpreting laws, they make laws. That is why if you go to courts, you will hear lawyers saying in the case of so versus so, the Supreme Court decided that section so should be interpreted as. So in the course of interpreting a particular law, the Supreme Court ends up making laws. So this law forms part of the Nigerian law and it becomes a source of Nigerian law. That's why I have it here on the slide, precedent slash case law. So in the course of interpreting these laws, they make laws. For instance, now where a section of a law, let's say a law that regulates driving, says whenever you are driving, you must put you must not hold your. I'm thinking of whenever you are driving, you must not drive with your phone. You must not drive with your phone. So that's what the section says. So road safety will stop you and says, don't you know this section of the law that says whenever you're driving, don't drive with your phone. And you were not making a call, you were not doing anything. The phone was just beside you in the car. So they are using that particular particular law to take you to or to harass you or to make you pay a fine, and you decide to institute a matter in court. So when you go to court, the court will say, okay, that section that says when you are driving, you should be you shouldn't drive with your phone does not mean you cannot keep your phone beside you. It's just saying while you are driving, you should not drive and call, or you should not drive and surf the internet. So as a result of that interpretation by the court, they are making the law. So precedent, when I'm talking about hierarchy of Nigerian courts, we'll talk about precedent. So precedent, international law is another source of Nigerian law. International law is there to govern relationship between countries, independent countries. So international law can be private in the sense that it's regulating the relationship of citizens, private citizens of different countries, or it can be public in the sense that it's regulating the relationship between the states, the country as in at diplomat level. So we have various international laws that have formed part of the Nigerian law and have contributed to uh, making to Nigeria having some of its law, like we have the United Nations Declaration on Human Rights. If you check the Chapter 4 of the Nigerian Constitution and you compare it with United Nations Declaration of Human Rights, you get to see there are similarities because we have different treaties which Nigeria is party to, and we've domesticated and they form part of our own local legislation. We have customs and conventions. We have uh, yes, we have bilateral agreements between different countries that are form parts of our law. Some of the international laws are still applicable in our courts, like the African Charter on Human Rights can be cited when you are bringing action for infringement of fundamental human rights. It's something you can cite. Then let's have a rundown of hierarchy of Nigerian courts. So that is all on sources of Nigerian law. So we are going to look at the hierarchy of Nigerian courts. You know, I said the Supreme Court earlier. I said the Supreme Court is the apex court of the land. Once the Supreme Court decides a matter, other courts are bound to follow the decision of the Supreme Court, whether it is right or wrong. Whether the Supreme Court is right or wrong, the highest you can do is make a commentary as a judge or an arbiter as to the, but you are bound by the decision. All lower courts, the Supreme Court is the highest. So if matters will begin from lower courts, sorry, matters will begin from lower courts, they will go to Court of Appeal, then to Supreme Court as the final court. So the Supreme Court is the final court that decides the matter. Then we have Court of Appeal. The Court of Appeal is next to the Supreme Court. The Court of Appeal entertain matters from uh, courts of superior records like the Federal High Court, State High Court, National Industrial Court, tribunals, Court of Conduct Tribunal, all this, the appeal goes directly to Court of Appeal. If, as the name implies, Court of Appeal, if you are dissatisfied, you go to the Supreme Court. But there are matters that ends at Court of Appeal, like election petition that has to do with State House of Assembly and National Assembly. They don't go to the Supreme Court, they end at the Court of Appeal. Then we have Federal High Court, State High Court, National Industrial Courts, and uh, Securities and Exchange Tribunal, Tax Tribunals. All these are courts of coordinate jurisdiction. If I say courts of coordinate jurisdiction, is that if you institute a matter at Federal High Court and the given judgment in that matter and it is not in your favor, you cannot go to State High Court and say you want to institute an action. Moreover, if the Federal High Court does not have the jurisdiction to entertain your matter, then you can come and institute it at State High Court. If the State High Court does not have jurisdiction, you go to National Industrial Court. So Federal High Court is basically by virtue of Section 250, established by virtue of Section 251, sub 1, paragraph F of the 1999 Constitution. You get to see what the jurisdiction of the Federal High Court is. That is, what matters can the Federal High Court entertain. For instance, all matters that have to do with federal government agencies, when between federal government agencies, when it has to do with interpretation of acts like karma, you go to the Federal High Court. Matters that have to do with uh, patents, copyright, trademark, all intellectual property matters. Intellectual property matter are determined by the Federal High Court. When you go to State High Court has unlimited jurisdiction on criminal and civil matters, but it does not entertain matters that are to be entertained by the Federal High Court. And we have the National Industrial Court. The National Industrial Court is there to entertain labor matters, whereby matters that have to do with master servant relationship, employee employer relationship, employee employer relationship, uh, trade union matters, all are entertained by the National Industrial Court. So when you have matter that has to do, when you have a matter that has to do with labor, you don't go to State High Court and say you want to institute, because the National Industrial Court is there for such matters. We have the Sharia Court. The Sharia Court is there for persons who are subject to Islamic law to submit themselves to the jurisdiction of such court. Their matters are decided based on the Holy Quran and the Hadith. Then we have customary courts, as I said, they decide matters based on the customs and traditions of the people of that locality. So that's how they decide their matters based on the custom and traditions of the people of that locality. You see, customary courts and area courts have similar jurisdiction. It's just a matter of nomenclature. In the north, those kind of courts that adjudicate matters based on custom and traditions are referred to as area courts. While if you go to the south, they are referred to as magistrate courts. As customary courts. And then we have magistrate court and district court. Magistrate court has limited civil and criminal jurisdiction in that it can entertain criminal and civil matters. In the north, the magistrate court entertains only criminal matters, while the district court entertains civil matters. But it's the same judge that will entertain the matter. But when it comes to civil, they will just change the court papers will just carry district court rather than magistrate court in the north. But in the south, it does not matter. It's still the same magistrate court. So it can entertain civil and criminal jurisdiction. It has civil and criminal jurisdiction, only that the jurisdiction is limited. Limited in the sense that it's not all matters that can be entertained by magistrate court. If a matter that has to do with murder, matters that are punishable by capital matters that are of capital nature. That means life imprisonment and the rest. These are example of matters that cannot be entertained by magistrate court. Sometimes even land matters that where it has to do with urban lands and the rest. In some states, the magistrate court cannot entertain such matters where the money is of certain value. So magistrate courts cannot entertain such matters. So that is it on hierarchy of Nigerian courts. Then civil law, you heard of civil law, you have of criminal. You say, this person, he's being tried for a criminal matter. Criminal in the sense that uh, it's different from civil. Civil governs relationship between two citizens. My relationship with you. If I infringe on your right, you can sue me based on civil law. And normally there are remedies and available for such infringement on your personal right. So civil law confers obligations between citizens and which we are to respect. That's why we have things like defamation. When you say some statements or when you make some statements about someone which are untrue, the person can sue you for defamation. And defamation, it can be libel, it can be slander. Libel if it is published, and slander when it is uttered. So these are like trespass. When you are in possession of a property or you are paying for a rent or you've paid to rent a property from somebody, you have exclusive possession, whereby that person decides to encroach on that your property without your permission. That person is said to trespass. And these are things that govern the relationship between private citizens. Then when we talk of criminal law, even though You might commit a crime against a person, but the state, you are committing it against the state, because it is the duty of the state to protect the welfare of citizens, to ensure that the state is is conducive for members of the society to occupy. So if you commit murder, for instance, even though you committed such against an individual, you are not breaching that individual's private right. Rather, it is the state. You are affecting the 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 the, uh, the welfare of the state, because one of the responsibility of the state is to protect lives and properties. So once you take a life, you are committing a criminal offense. When you embezzle public funds, you are embezzling money meant for the public. Such is also criminal. So we have the judiciary, we have the police, we have the EFCC, we have the criminal justice system is there for that purpose. So I believe now, if you are asked what the Nigerian legal system is all about, you have an idea of, you can tell somebody what you know about the Nigerian legal system. You can say what you know about sources of Nigerian law and the hierarchy of Nigerian courts. You can differentiate between civil law and criminal law. Criminal, more of you are committing, and criminal law is mostly they are prescribed one, and they are written, and uh the punishment is stated, the offense will be written, the punishment will be stated, and the penalty is also stated. So that's criminal law for you, unlike civil law where it is hardly written, but from court decisions we can infer what the likely remedy will be for such breaches. So let's look at relevant regulatory agencies responsible for regulating businesses in Nigeria. So these agencies, all they also form part of the Nigerian legal system. These agencies also form part of the Nigerian legal system. So we look at the Corporate Affairs Commission, we look at the Federal Inland Revenue Service, we look at the Central Bank of Nigeria. So when we talk about the Central Bank of Nigeria, you know the Central Bank of Nigeria is the apex financial institution in Nigeria, and is there to regulate how financial institutions are carrying out their businesses in Nigeria, and sometimes non-financial institutions too do their business in Nigeria. It lays down the framework for them to go about doing their businesses. And the CBN is not just regulating financial and some certain non-financial institutions, but it's also rolling out general policy to ensure the growth of the Nigerian economy. Like, it's the responsibility of the CBN to either increase the lending rate or decrease the lending rate. All these are done for the purpose of ensuring that people can access loan. And of recent, the CBN has come up with several intervention programs for the purpose of ensuring that the economy is going on fine, like programs like this particular program here that going now is one of the intervention programs that the CBN introduced, the Anchors Brewers program, so many programs that the CBN recently they introduced the one for remittance. For every $1 you get 5 naira. All these are done to ensure that there is liquidity flow in the Nigerian economy. So these are some of the responsibilities of the CBN. Then we have the Asset Management Corporation of Nigeria. The Asset Management Corporation of Nigeria, AMCON, is there to ensure that there is flow of money within the Nigerian financial institution. So it is the responsibility of AMCOM to ensure liquidity flow and in the Nigerian financial sector, and it does that through the severance of toxic assets. So for instance, now it is the responsibility of AMCOM to go after debtors that are indebted to banks. And it's not like they go after those debtors because they are indebted to bank. What happens is that uh, AMCON will normally go to these banks and ask them who are where the AMCON will meet those banks, will look at their balance sheets and see those loans that are non-performing loans. That means persons that have borrowed, institutions that have borrowed, companies that have borrowed money from these banks that are no longer servicing such loans. So what AMCON does is it will look at the balance sheet of such companies and of such banks and say, okay, we are going to buy off the loan from you, so that these people will no longer be indebted to the banks, rather they will be indebted to AMCON. That is why sometimes you hear that AMCON is releasing names of debtors in Nigeria. You'll be wondering, what concerns AMCON with name of debtors? What happens is that AMCON normally buys off the debt from the banks with interest, even with the interest on top. Then AMCON will go after those debtors. For instance, now there's a company called Nigerian Swan Limited. So Nigerian Swan Limited goes to a particular financial institution in Nigeria, let's say CS Bank, to obtain loan of 100 billion. Uh, the paperwork, everything was going on fine. They were servicing the debt. Then suddenly, Nigerian Swan Limited encountered problem. They couldn't service the debt. The loan became non-performing. As a result, it will become a toxic asset to the bank, because the bank will now, because that loan is not being serviced as a result of uh, the activities of Nigerian Swan Limited. So what AMCON will do is that it will go to XC Bank and say, let's have a look at your balance sheet and let's see those debts we can buy off from you. So that debt by Swan and Nigerian Swan Limited will be bought off by AMCON, and AMCON will go after Nigerian Swan Limited. So the bank is no longer indebted to Nigerian Swan Limited. Rather, it is AMCON now that will be going after the debtors. This is to ensure that other people can approach the bank for a loan. So that is the responsibility of AMCON. So it's normal for you to hear AMCON have seized the properties of so person for the purpose of setting their debt. If they fail to pay, they'll go and sell the property and recover their money. So we also have National Agency of Drug uh, Administration and Control is another agency, regulating regulatory agency in Nigeria. We have the Standard Organization of Nigeria, Federal Capital Development Authority is also another uh, agency responsible for regulating business. Let's look at the Corporate Affairs Commission in details. Corporate Affairs Commission was established by the KAMA of 1990, and you could see from this slide the responsibility okay, CAC is responsible for regulating business and non-business, for is charged with the registration and regulation of business and non-business organizations, such as companies, business names, business names, and incorporated trustees are some of the business organizations that could be registered with that are registered with CAC. So if you have business organizations like companies, business names you want to operate, you use CAC to register such companies. Sorry about that. Then you have non-business organization like churches, NGOs, non-profit organizations. These ones you also use the CAC to register such companies. So by the lecture of section 7 sub 1 of KAMA, some of the main functions of CAC include regulation. Before you form it is the responsibility of CSE to regulate your company after formation. One of their responsibilities is supervision of the formation of company. In the course of registering your company, they supervise. So they supervise the formation of the company. Then after you submit, you must have submitted your registration to CSE. They will incorporate the company. After they've incorporated the company, they will issue a certificate. After issuing a certificate, they go ahead to regulate the activities of the company, not like directly determining how the company will run. No, like if you want to file documents, change of, of, of of directors, change of increase in share capital, removal of directors. There are CSE regulations that are governing such. There are procedures provided by CSE on how to go about doing all such things. Then it's also if you want to wind up your company, if you feel the company is no longer a going concern, you don't want to continue running the company, you can also approach the CSE to wind up the company for you. And it's also the responsibility of CSE to maintain the company's registry in all states of the federation, so that if you are filing anything, the CSE will get to know, or if people want to access the company's register to see who the directors are, CSE will have access, and you can have access to it from CSE. So it's the power of CSE to carry out investigation into the affairs of the company if the situation demands. So once you are registering any business or non-business organization, you have to submit to CSE the objects or what that particular organization will be doing. So if eventually in the course of carrying out your activities, you are not doing what you told CSE you'll be using the company for, CSE can carry out investigations. And if we carry out investigation and discover you are going contrary to your objects, they'll set up an administrative panel where they will give you fair hearing why they should not take over the administration of that particular company. So if you prove to them why, then they will not take it. But if otherwise, they will take over the regulation of such church by appointing their own trustees and the rest. So if you are dissatisfied with the decision of the administrative panel, you can institute a matter in court. So these are just the functions of CSE. And you know that if you want to register your business and non-business organization, the right agency to approach is the CAC. Then we have the Federal Inland Revenue Service. So the Federal Inland Revenue Service is charged with the responsibility for the collection and the administration of federal and corporate taxes. That is the responsibility of is the responsibility of the Federal Inland Revenue to do that. So, and the Federal Inland Revenue is also administer the and control the enforcement of the various tax enactments. It's also the responsibility of the Federal Inland Revenue. It's also the responsibility of the Federal Inland Revenue to ensure that it's also the responsibility of the FIRS to administer to control and administer the different tax laws specified in the first schedule, and it's also the responsibility of the FIRS to enforce, aside administering the various tax enactments, it is also their responsibility to enforce it. And when we are talking about tax enactments, we're talking about Personal Income Tax Act, we're talking about Companies Income Tax Act, we're talking about Stamp Duty Act, we're talking about the Value Added Tax Act. All these acts and others are administered by Federal Inland Revenue. For the purpose of this module, We're not going to look at the various tax and enactments. We're going to limit ourselves to the Value Added Tax Act and what Value Added Tax is. Because regard when we look at the kind of training you're undergoing and the kind of businesses which most of you are engaged or will be engaged in are those ones that will require you remit VAT to the federal government. So when you are talking about VAT is so we are just going to streamline our discussion to value added tax. So when we are talking about VAT, it simply means value added tax. It's another tax that is administered by the federal inland revenue, and it's the responsibility of every businessman in Nigeria who is into selling or providing any service, any kind of service that is vatable to remit his or her VAT to the federal government through his local VAT office, which is the FIRS within that particular locality. So when we talk of value added tax, we're just VAT is just a consumption tax that is levied on a product repeatedly at every point of sale, at which value has been added. That is VAT is the consumption tax. That's why I said if you are selling a product that is consumable, is a consumable product, or you are offering a service, then you must uh, collect VAT that you remit to the federal government. For instance, if you go to the supermarket, let's say you go to the supermarket in the morning, bought a pack of Coke, you see they will include VAT. When you go back in the afternoon, you bought another pack of Coke, you will still include VAT. You go back in the evening, you bought another pack of Coke, you will still include VAT. So that's why it said VAT is tax that is levied on a product repeatedly at every point of sale at which value has been added. So it also applies to services that are offered. So as for participants or as for participants that will be going into business that will have to do with selling stuffs or providing services that are vatable, you need to go and register with your local VAT office. Then you obtain and complete your VAT form and return it to the nearest local VAT office. A VAT registration number is to be given to each registered payer, and by so doing, you get to be remitting your VAT to that particular local office. So, however, it's not all products that are vatable. If you check the Finance Act, you get to see which products are not vatable. But for instance, here I mentioned cultivated of processed agricultural produce exempted from VAT and enjoy pioneer status, thus are largely exempted from federal taxes. So let's look at Standard Organization of Nigeria too, as one of the regulatory uh, agencies regulating businesses in Nigeria. The Standard Organization is the sole statutory body that's vested with the responsibility of standardizing and regulating the quality of products contained in its inventory in Nigeria. You standard organization of Nigeria, as the name implies, and from what I've just read from the slide, you can see they are there to ensure standardizing and regulating the quality of products that are sold in the market or distributed or exported or imported into Nigeria. So it's their especially when you are importing or exporting with the sole aim of distributing it or selling it to make profit. Or you are manufacturing, it has to meet the Nigerian industrial standard, and it's the responsibility of the standard organization to ensure that. So is I think there's it's not I think there's an inventory that is released by Standard Organization of Nigeria, always containing the list of products that you are manufacturing, you are importing, or you intend to export, and you are distributing that. You need to standardize with them.
So you need to check their inventory and see whether what you want to go into the distribution of or manufacture of is in that inventory. If it is in that inventory, then you will have to go and register with the Standard Organization of Nigeria. Though sometimes there can be conflict between the Standard Organization of Nigeria and NAFDAC, but if you check the NAFDAC Act, you see the NAFDAC Act is quite deliberate as to what kind of things you need to register with the with NAFDAC. So we'll look at that too subsequently. So what are the functions of Standard Organization of Nigeria? As you can see, to investigate the quality of facilities, to ensure reference standard for calibration, to compile an inventory of products requiring standard, to foster interest in recommendation and maintenance of acceptable standard, register and regulate standard marks. You can see them all on the slide, and a copy of the slide will be posted on the platform, so you get to see them. And one of the implications if you fail to register with Standard Organization is that Standard Organization of Nigeria also has the power of seizure, classification, and destruction of substandard products, including powers to seal up premises where defective products are manufactured or stored. And there are procedures for registering with Standard Organization of Nigeria. They have the e-product registration, the e-product registration for imported and locally manufactured products. You, yeah, you have a company, definitely you have a company, you are manufacturing, you check their inventory and you've seen that what you are manufacturing or what you intend to import or what you intend to export or whatever you intend to distribute in the market is, is in their inventory. You have to go to their portal, sun.gov.ng. You click on e-product registration, and you continue, you press continue. For a new company, as in you open a new account, you don't have an account with them. The procedure, you will see or if you go to their page, you get to see that new account. You enter your RC number and a valid email address. You sign up. You follow the procedure 1 to 6 as contained here. 1 to 8 as contained in this slide. And there are documents you need to upload after you must have logged in, created your account, and put in the necessary information required by Standard Organization of Nigeria. Then documents you upload, and these documents, they will not be more than 30 kilobytes. So you need to compress the documents, fit into the required size. And such documents include the CAC certificate, picture of the product, power of attorney. If you are an importer, that means power of attorney is simply a document saying you have been empowered to do something on someone's behalf. So that's what the document will say. Trademark certificate if you are a manufacturer or you are a brand new. You need to register with the trademark, patent, and design registry of the investment and trade ministry. So their office is at area 11, or sorry, area 1 at yes, 4 old federal secretariat. That's where their office is located. So if in case you want to register your trademark or anything. So that's the procedure for registration with Standard Organization of Nigeria. They also have other forms of programs which they have made for the purpose of registering your products or those products that are contained in their inventory. So they have what they call the mandatory conformity assessment program. This one is for only for locally manufactured products in the country, so that they will ensure that they conform with the relevant Nigerian industrial standards before they are distributed in the market. So the procedure is quite long, and how they go about it. And it's also stated on the slide. You can see the procedures for MANCAP certification, inspection of the product, production process, sampling and testing of the products, report of inspection and test results are complied by state offices. If the product meets the requirement of the relevant industrial marker certificate and marker logo, which bears the unique number for that product is issued. A marker logo is to be fixed on the smallest unit pack of the product after the product must have undergoes certification. So if for details on how to go about registering with Standard Organization of Nigeria, log into www.618biz.com. There you also find detail of better, more elaborated step-by-step procedure on how to go registering with Standard Organization of Nigeria. And there's also another program by Standard Organization of Nigeria, which is called the Conformity Assessment Program uh, for for goods shipped to Nigeria. So if for goods shipped to Nigeria too, there is also another program that has been that has been made by the Standard Organization of Nigeria to ensure that the quality of those products that are shipped into Nigeria of standard and they met the required specifications. So you could go to www.cotina.com or you could just Google export guides to Nigeria where you get details of such. So that's it for Standard Organization of Nigeria. So let's look at NAFDAC. NAFDAC too is also another agency responsible for regulating business in Nigeria. So NAFDAC has the mandate for controlling, maintaining the distribution, advertising, exportation, importation, manufacture, and the registration of the categories of products such as food, drugs, medical devices, and cosmetics. We need to see what the responsibility of NAFDAC. You see, controlling, maintaining, distribution. So if you intend to distribute food, drugs, medical devices, cosmetics, you need to register with NAFDAC. If you intend to advertise, you need to register. You need to do that with the consent of NAFDAC. If you intend to export any of the categories of products that are mentioned in the NAFDAC Act and that are specifically stated that is for NAFDAC to administer, you need to do that. You need to do that. You need to obtain or register with NAFDAC to do that. Manufacturer, which is very important, you need to obtain a NAFDAC registration number and anything of these categories of products. So all businesses dealing with food and related products are subject to regulation by NAFDAC, and as it is unlawful to market any drugs or consumable goods in Nigeria to the public without registration with NAFDAC. So it's unlawful for you to distribute goods to NAFDAC without registration. And also, let's look at what are the categories of products that are to be that are administered by NAFDAC, going by the provision in the Act, the NAFDAC Act. What are those products? So if you go to the NAFDAC Act, you will see that the categories of products that are to be administered by NAFDAC include food, uh, food and water, drugs and medical devices, herbals and cosmetics, vaccines and biologics, chemicals, veterinary products, and narcotics. All these. So once you want to go into the distribution advertising, exportation, importation, manufacture, and registration of food and water, drugs and medical devices, herbals and cosmetics, vaccines and biologics, chemicals, veterinary products, and narcotics. It is, you have to register with NAFDAC. It's very important. If not, you risk having your products confiscated, or it will affect the market value of your product. Because subconsciously, when you go to buy drugs in the market, in a pharmacy, you check for NAFDAC registration number to ensure that yes, that particular drug is recognized by NAFDAC. So uh, that is it on the categories of products to be administered by NAFDAC. So let's look at the registration procedure. Because of time and because regarding how bulky it is, to say we want to consider registration of under food alone, we have different types of foods that can be registered with NAFDAC. Under drugs, we have millions of drugs. So we cannot say we will pick each and discuss. One, we can't do that. Two, time is not even on our side. So what we just look at is a general requirement for registering products with NAFDAC. Then we'll also look at the general requirements for registering drugs with NAFDAC. So though there might be specification as to registering certain drugs, but the general procedure involved in registering products with NAFDAC. One is application for approval to bring in samples when you want to import that particular product. But when you want to manufacture it, it's not applicable. Then full registration with NAFDAC, whereby certain information will be required from you. So let's look at the registration, the key requirements when it comes to registration of drugs with NAFDAC. So application is a one is on a single product basis. When it's a single product basis, what I mean by that is that you cannot have apply for one NAFDAC number or two different kind of drugs. Let's say you have a drug for drug for headache, and a drug for stomach ache, and you applied that should be issued a single NAFDAC number for the two products. It's not going to work that way. So it has to be application has to be on a single product basis, separate for the drug for headache, separate for the drug for uh, stomach ache. Then written application stating the manufacturer and name of the brand, completed NAFDAC application form, certificate of completion to the Corporate of Affairs Commission. If it's a company, you need to attach that. Then you need to attach your 5 copies of the product dossier. Product dossier is for every drug or any vaccine or anything, you have to carry out research. Just for instance, the corona vaccines we have, we have Moderna, we have uh, AstraZeneca, we have Johnson and Johnson, we have Sinovac. Different vaccines have sprung up. So these vaccines can researches were done and data analyzed before they were finally uh, uh, put out there for for public use. So if you are applying to NAFDAC, you need to submit that product dossier to show them, okay, all those things were conducted, research and other things were all done. Then 3 parts of the product sample too. You need to bring that along with your application to NAFDAC. Then where you are importing the product, you need to have a power of attorney. As I said earlier, it's just a document that empowers someone to do something on behalf of somebody. Then we have a certificate of manufacturer, or issued by a competent health or regulatory authority in the country of origin, identified by the Nigerian nation. In that country, if where there is no Nigerian nation, then British High Commission or ECOWAS confirmation on will authenticate such for you. So these are some of the requirements for importing drugs into Nigeria. Others include you have to give NAFDAC letter of invitation if you are importing the product for them to visit the plant. And you know definitely you need to pay the applicable fees for the document. Then you have to, if it is a brand, you need to register, just as I said earlier, with the Trademark, Patent and Design Registry of the Federal Ministry of Trade and Investment. So you need to register with them to obtain your trademark certificate, which will last you 7 years, which you can renew for another, I think the subsequent renewals for 14 years. Then, earlier while mentioning the function of NAFDAC, I said they are also responsible for distribution, controlling the distribution of those categories of products that are mentioned in the Act. And one of such things that one of such means to distribute uh, drugs is the pharmacy, and NAFDAC plays an important role there. So the pharmaceutical product duly issued and authenticated, the certificate of it must be presented if you want to open a pharmacy. Must be presented to NAFDAC. Current pretender pharmacist license to practice issued by the Pharmaceutical Council of Nigeria, premises registration license from the Pharmacist Council of Nigeria, all need to be presented to NAFDAC for you to operate a standard pharmacy. I said pharmacy, I didn't say chemist. A standard pharmacy to avoid harassment and the rest. Because if you don't do that, I guess you are breaking a chemist in one corner or something. So you need to do that. You need to obtain license from NAFDAC to do that. NAFDAC too have also introduced or are trying to work or they've introduced an e-registration procedure, which they refer to as the NAFDAC Automated Product Administration and Monitoring System. So, it's like their own e-registration procedure whereby you just go and log in, you register, you, you impute all the data you need to impute. Definitely, there are documents, you need to upload those documents, and you can just go to www.napams.org. So NAPAMS is gotten from the abbreviation of the National Automated Product Administration Monitoring System, NAPAMS.org, where you get to uh, apply for your NAFDAC registration or obtain a license or permission to attend to clients via that site. So all these things, if you can't do, there are professionals from Standard Organization of Nigeria to NAFDAC licenses and permits and whatever you need. There are lawyers that are on ground or agents that will help you process those permits or license for you to do what you want to do. So we've come to the end of the first arm of the lecture. Now we are on the second arm, which is types of business organization and the legal implication of the various types. So when we say business organization, we are talking about legislative ventures with profit. And what are the types of business organizations we have? We have sole proprietorship, we have partnership, and we have company. So we are going to look at this business organizations and look at what their legal implications and what are the legal implications of running such business organizations. So when, as the name implies, sole proprietorship, this is the business that is run by one person, and one of the legal implications is that the person, if he dies, the business dies with him. The advantage is that he gets to enjoy his profit alone, he gets to take decisions alone, and nobody to disturb him. And one of the disadvantages or one of the legal implications of running a sole proprietorship is that his liabilities will be personal, where he's indebted to a financial institution or he borrows money from a particular organization. In that case, his 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 liability will be personal. That means they can come after him, his personal belongings to offset debts. For instance, Mr. Johnson is running a business venture, a business venture which he calls Johnson Ventures, and he decides to borrow money from GT Bank and he fails to pay, and GT Bank went to court, obtained judgment against Mr. Johnson. So if GT wants to enforce that particular judgment, because Mr. Johnson is a sole proprietor, he can come after his personal belongings, his beddings at home, pots in the kitchen, washing machine, anything, television, anything they can lay their hands on to offset their debt, they will come after it. That's why I have it on the slide. Personal assets like car, properties of the owner may be seized to offset the debt of the business. Then the business, even if registered with CAC, is not a separate legal personality from the sole owner because it's still not a company, neither is it an LLP, neither is it a partnership which is limited, but the owner will still be personally liable. So let's look at partnership and its legal implication. When we say partnership, there is two or more persons coming together to either provide a service or to sell a product to the public or to offer a service, as I said. So, and we have different types of partnership. We have limited partnership, we have general partners, and we have limited liability partnership, which is LLP. Limited liability partnership is kind of a hybrid kind of partnership where it has the semblance of the company, the features of the company that are also similar to that of limited liability partnership. So, except in the case of partners who are limited partners, partners in limited liability partnership and general partners have unlimited liabilities similar to a sole proprietor. General partners. So general partners is when two or more persons come together and say we want to be general partners. For instance, Mr. Johnson and Mr. John will come together that okay, we want to run a partnership. We want it to be general partnership in the sense that both are actively involved in the day-to-day running of the business. Nobody is just investing and sitting back. All of both of them are actively involved. In that case, the legal implication is that one, the legal implication is that one, when they borrow money from any financial institution, they will come for their personal belongings, so will be seized to offset the debt and liabilities of the partnership business because it's a business made up of two or more partners, each sharing the business's debt. To remove this S, to remove this S. So liabilities and assets. Then when we talk about a limited partnership, exists when two or more partners go into business together, but one or more of the partners are only liable up to the amount of his or their investment. What happens in limited partnership is simple. What happens in limited partnership is that the one of the partners would say he is not involved in he doesn't want to be involved in the day-to-day running of the business. He only wants to invest. Let's say Mr. Johnson and Mr. John have decided to go into partnership. Then Mr. John approaches Mr. Johnson that okay, I want to be partner, but I want to be limited partner. That means his liability is only limited to the amount of investment he's making in the partnership. So where the partnership borrows money, for Mr. Johnson, he will personally liable as his personal belongings will be seized to offset the debt. Whereas for Mr. John, who is a limited partner, in that case, his own belongings, personal belongings, will not be seized to offset the debt because he's just a limited partner. Only his investment in the company can be affected. So that is it on general and legal partnership. So let's come to limited liability partnership. Limited liability partnership, as I said earlier, is a hybrid. It has a semblance of company. So it's a body corporate with a legal personality separate from its members. The members are not the same as as the partnership. It is a hybrid business form that infuses two types of business, a partnership and a limited liability company. The legal implication of LLP is that partners enjoy limited liability where the entity is sued. The liability of its partners will be limited only to the amount contributed by each partner for the formation of the LLP. So the LLP enjoys, what are the legal implications? What are those things that the LLP enjoys? The LLP enjoys perpetual succession. The life, that is, the life of the LLP is not affected by the demise, retirement, insolvency, or withdrawal of any of the partners. They can sue and be sued. They can buy properties in the name of the partnership. So these are some of the legal implications of running a partnership. Though partnership is the legal limited liability partnership has the semblance of a company, it does not it is not, sorry, it is not a company because LLP are registered mostly to provide services like law firms, accounting firms, consultancy firms, all those professionals that normally provide quantities of various and that normally provide services are the ones that are likely to register LLP, Limited Liability Partnership with the Corporate Affairs Commission. But when you want to go into buying and selling, you want to go into production of goods, manufacture, importation, the right thing to incorporate is a company, not a partners LLC. Because you can incorporate a company with your shareholders, you can reach an agreement on how you share the company's profit. Even the partnership is also an agreement on how to share profit, which I'm coming to now. For you to say you are a partner in any business, profit must be shared equally, except agreed otherwise with a partner. But if you don't partake in the sharing of profit, then quote and unquote, you are not in any partnership. You are just helping the person to run his business. Here I have the determination of who is the partner in your business is whether the person partakes in profit sharing. It's paramount. Then let's go to company. Company is quite special in the sense that companies like LLP, they have a separate legal personality from the shareholders. So the fact that Mr. Johnson is the one that paid for the incorporation of the company, is the one that paid for the rent of the company, is the one that paid for the company's vehicle, does not make him one and the same with the company. If he buys or if he buys the cars, the properties in his name, then that is his own property. But if he buys those, if those properties were bought in the name of the company, then those properties belong to the company. That is why companies have a separate legal personality. In law, companies are regarded as artificial persons, while individuals like Mr. Johnson will be regarded as natural persons. So anything a natural person can do, an artificial person like company can do. So what are the legal implications of running a company? So one is that if the company is a legal personality on its own, separate from the shareholders. That means the shareholders of the company have limited liabilities. Their liabilities are limited to their investment in the company, uh, except for unlimited companies. Whereas for limited, your liability is limited to your investment in that company. So shareholders, when the company is indebted, shareholders are only liable to their the debt and liabilities of the company is not the debt and liabilities of the shareholders. And as their debt and liabilities are only limited to their investment in that company. So their personal assets of the shareholders cannot be seized to offset the debts and liabilities of the company. The company, being a human being of its own, can do the following in its registered name. Anything a natural person can do, an artificial person can also do. To buy and own the properties, to enter into contract, to sue and be sued, and the company will enjoy perpetual succession. That means it will be forever. I love to use First Bank as an example because if I check the logo of First Bank, I usually see since 1894. So 1894, the First Bank was incorporated. So if you check, you telling me that the initial shareholders, the initial directors are still alive? So that is one thing company enjoys: perpetual succession. It lives forever, except the company is wind up. Companies too can die. So when you apply for them to be wind up, or they can die a natural death, in the sense that the CAC can deregister the company from its registry, and it's no longer an artificial person, and you can no longer carry out business in the name of that company. So let's look at registration of business and non-business organization. Why do you have to register your business? We've seen that recently the government have introduced a number of intervention programs for the sake of improving the Nigerian economy as a result of the COVID-19 pandemic. So if your business is not registered, you get to miss out on some of these programs because you have to have a registered company. Even this training you're undergoing, they will advise you to register a company for you to access the loan. So these are some of the things and why and you must pay your tax and the rest. This is why we talked about regulatory agencies, we talked about the Nigerian legal system, and we also talk about contract subsequently because if you incorporate such companies, you go into business and your day-to-day activities, you are entering into contract. So the benefit is corporate and fiscal product registration. You get, if you are not registered, some financial transactions you cannot carry out if your company is not registered. You cannot even open an account if your company is not registered in the name of that company. You can only open an account in your personal name, whereby you'll be carrying out business transactions in your name, and which is not advisable. Money meant for the company should not be going to your own personal account. But unregistered products with NAFDAC and standard organization, you risk the losing such products because they might be confiscated and destroyed by the standard organization of Nigeria or NAFDAC. So registration for tax is also an important social responsibility, both from a legal and moral angle. So when we look at this, we look at there's need for you to register your business. The advantages outweigh the disadvantages because you will be paying your tax to the government, to be remitting your VAT and the rest, which is part of your social responsibility. Then small business startup procedure. Find what are the things you need to look out when you want to start a business if you've not begun one already. You look for a suitable business name, suitable business name to support your business idea. A suitable business name, identify suitable business location. You definitely you must have done your feasibility studies, you must have carried out your market survey before you decide to establish a business within a particular environment. Register the business with CAC, choose a name that's easy to pronounce, register with NAFDAC, with FIRS for remittance of your VAT, and then with the Standard Organization of Nigeria. If any of the things you want to produce or want to distribute or you want to import falls within the categories of products that are administered by NAFDAC, you know what you need to do. If the product is listed in the inventory of Standard Organization of Nigeria, you also know what to do. That means you need to go and register. So what are the procedure? This is very important. How to register your business with the CAC. What are those documents? How do you go about registering your business with CAC? So before I go about discussing this, I want to let you know that first, what you can register with the CAC are business names, which they can be registered as sole proprietor. You can register business name as sole proprietors and partners, or you can register a business name as partners. You can register companies, and we have different companies. You can register uh, incorporated trustees like churches. But for the purpose of this module, we are just going to discuss business name and companies. We're going to restrict ourselves to business name and companies because most of uh, it is believed that most participants will go into business or manufacturing of something or providing, and yes, they will go into a manufacture, they will go into manufacturing of certain products or providing certain services that will just require them registering a business name or a company. So first of all, for you to begin your registration, and companies and business and non-business organization, as I said earlier, I registered with NAFDAC. For you to begin your registration with, I registered with the Corporate Affairs Commission. For you to begin your registration with Corporate Affairs Commission, you need to know two things. One, you can register yourself. Two, you can use an accredited agent to run your registration. And who are those accredited agents? Accredited agents are either lawyers, chartered accountants, and chartered secretaries. But with the provision made by CAC that you can run your registration yourself, let me tell you how you go about doing that. First of all, go to their website. You can just Google for easy access. You can just Google CAC portal where it will direct you to their portal. In their portal, you get to see online registration. Online registration. So you click on online registration. Or on that online registration, you get to access what uh, what online registration. You go down, you scroll down, you get to see uh, uh, some options. And one of such options is for you to register to open an account with CAC. So you can start by clicking on that. You give them the necessary information where you register with them. Then you get to create a portal with CAC. By that registration, you get a password and you get a username and a password, which you use in accessing a portal that will be created for you to do your registration yourself. Where you cannot finding it difficult to do it yourself, get to contact one of the agents to do the registration. You bear it in mind, you definitely pay professional fee for such registration. After you've gotten created your portal, the next thing is get a suitable name, as we said. And for CAC, the names must be names that are not similar. They must be names that are not in use. The names are not in use by other persons. names that are not restricted, because there are some names that are restricted. For you to use them, you must have obtained permission from CC, or you must have gotten the the, the consent of the RG for you to use such names. So you have to look for a unique and easy to remember name that will likely scale through. So once you get the name, you get to go to uh, you log into your portal, then you go to new reservation. So you click on new reservation. When you click on new reservation, you get to see some option where you get to put in the name. It will ask you whether is it a company you want to register, or is it a business name, or is it a limited liability partnership. So you get to choose. Since we are talking of business name now, you get to choose business name. You click on business name. So once you click on, I know it's quite abstract what I'm saying until you send it on computer, or you've gone to the site yourself and you see, because now what I'm saying might sound abstract to you, but it's very easy when you begin. You see the steps. It's just like operating your handset, to or your mobile phones. So when you begin, you go to new registration, or sorry, new reservation, you click on, you get to choose whether it's business name. Since we're talking about business name, you click on business name. You have two names that you get to enter. You enter the names. You indicate whether your business name is it partnership or sole proprietorship. If it is one proprietor, it's sole proprietorship. So you indicate sole proprietorship, you proceed, you put in the nature of business of the business name or the business you want to go in, you put in the nature, you proceed to you preview your your nature of business, then you make payment. There's payments they do make for reservation. So once you make that payment, you proceed to you wait for the name to be approved by the commission. Once the name is approved by the commission, it will be emailed to you that your name has been approved. So there is a code that will be sent to you for the purpose of conducting that registration. And it's that code that you use to begin your registration. That code will be sent to your mail. So you still log into your portal. This time, instead of going to new name reservation, you go to new registration. Click on new registration. Once you click on new registration, it will take you to where you get to insert the code that was given to you by CAC via the mail that was sent to you. So once you insert the code, you get to begin your registration. You get to fill the forms where they will ask you for your name, your address. Okay, they will ask you for, yes, they'll ask you for the nature of the business, the address of the business, the state where the business is located, the local government. These are information you enter. Next is your address. You enter your address, your name. If you intend to have a branch, your means of identification, which could be either be your driver's license, it could be your driver's license, it could be your international passport, it could be your voter's card. You need to you upload that passport photograph, and you also upload your signature. You also enter the nature of the business, get it. All these are informations that are required by CC. After you've entered all this information, then you get to upload your your means of identification, your signature, and your passport photograph, which just one passport photograph. After that, you make payment. For reservation of name, I said you make payment. When you want to submit your document to CAC, you also make payment. And let me take you back to reservation of name. Names are reserved for 60 days. So if you are not able to complete your registration within 60 days, that name will disappear. You will no longer have that name. You have to reapply for that name again to be given to you. So it's reserved for 60 days. So after you've submitted your documents, receipt for your payment will be sent to you, whereby you if you want to, you can download the receipt, then you submit, you wait on CAC to approve your application. If it is not approved, it is queried. If it is queried, you resolve a query, you go and check what is it they want you to correct that you've entered that is not correct, you correct it, then you move to you resolve the query, then you click on resolve because once you have resolved the issue, you come back and click on resolve. You go to your portal. All these things are on your portal. By the time you begin with your portal is created, you get to see name reservation, you get to see company registration. So under company registration, you get to see which companies you submitted, which companies are awaiting approval for CC, or be it company or business which is awaiting approval. So once your registration is approved by CAC, you get to access your you get to access your this thing from your portal, your certificate from your portal. There your certificate and your status report, the status report on the company from your portal. So you just download it. Anytime you want the certificate, you just go to your portal and download it. So that's it on registration of business name. Then we have example of business name like Taiwan, Taiwan Global Ventures Fund, etc. So when it comes to company, the same as I said earlier, company can be private limited company, it can be public limited company, it can be a limited company, it can be limited by guarantee. But for the purpose of this model, we're just going to consider limited company and private limited company and public limited company. Uh, and I have you have private limited company and public limited company. So we'll just quickly look at private limited. Public limited company are the ones that are mostly quoted on the Nigerian stock exchange. So we have the private limited company, which is advisable for small and medium businesses. For you that will be entering into small and medium businesses, so it's advisable you use the private limited company. The first step for registration is the reservation of name. The same procedure I explained for business name is applicable to company. Only that this time, instead of clicking on uh, business name, you click on company, and the company will appear private, limited, public, unlimited, limited by guarantee. And if you want to go into small medium, it's private, limited, you choose. Submit your notice of approval, you make payment. If it is approved, and you create portal just like the business name. And I say you can't do it yourself. There are accredited agents that will help you run the registration. Then you complete your CAC incorporation forms, detailing personal information like the share capital of the company. When we say share capital, it's just an artificial valuation of the company, like 1 million share capital divided into 1 naira of one share of 1 naira each. So all these are informations that will be required. The directors, the shareholders, persons with significant control in the company, all this will be required. One thing about this newcomer is that it has introduced a new innovation, which is one director. You don't need at least two directors to register company now. You can register with at least one director, one shareholder, if it is a small company. But any other company other than small company, you have to have at least two directors and two shareholders. You feel objects of the company. Then, as for articles of association, you will adopt that of the CAC. Registering company is quite cumbersome, unlike business name. So business name is simpler than that of company. So I would advise, because of some technical things that you might find, you could consult someone if you are doing it yourself, or self yourself distress, you approach professionals to help you do that. Then after, you must have filled all the necessary informations, then you submit, you make payment to safely, then you await approval of your company. That company too, once approved, you get to access the certificate from your portal. So that is it on procedure of registration of business in your company. So let's quickly look at the last topic, which is law of contract. And we're talking of contract now because once you register this business, what you go into is on day-to-day basis is contract. The normal buying and selling you do is contract. Parties do not have to sit down on a special table drafting papers before you continue. You've entered into contract. So the first features of contract, three basic elements of contract I want you to have in mind is offer, acceptance, and consideration. Offer is is you approaching and saying you want to buy a product, or somebody approaching and saying he wants to buy a product from you. That is offer. There must be acceptance. If there is no acceptance between parties, then there cannot be contract. And to cap it all, there must be consideration, something of value, money must exchange hands. Other things that might follow later is the form of the contract. Is the contract oral? Is it by conduct? Is it written? These are things that will also be considered. Then the capacity. What is the capacity of the parties entering into the contract? Are they of age? Are they adults? What is the legality of the contract too is another thing that will be considered. Is the contract legal? Because it's not all contracts that are legal. Then are parties, is there the intention to create legal obligation between parties? It's also something. Then let's look at privity of contract. When we say privity of contract, only means only parties to a contract can sue. Mr. Johnson and Mr. John entered into a contract, and there are some breaches of contract that can be as can be pointed to one of the parties. So Mr. John and Mr. Johnson are the only two parties to that contract. Any other person cannot come and sue on behalf of any of them, because they are the two parties to the contract. That's why it's that particular term, privity of contract, is just the only party to a contract can sue. There, although there are exceptions, just in general, there are exceptions. So you could just do a little research and check. I'll give you the exceptions, but I'll not explain them. Just do a research, check what the exceptions are talking about, like covenants running with land is an exception to privity of contract. When you interfere with third party is an exception. Then I can't recall the third exception. Then the terms of contract. Terms of contract can be expressed or implied. Expressed in the term in the sense that all the terms are expressed. You can read them directly. While implied is from some of the expressed terms that it will be implied. For example, if you're buying a wristwatch from somebody, even though it's not stated that the wristwatch must be working at that time, it is implied that you are buying that wristwatch because it, it is a wristwatch, and wristwatches are used to check time. So if the wristwatch is not working, then there's no way to check time. So even if it's not expressly stated in the contract, it is implied. So what are those things that are likely to reshape a contract? When you enter into a contract under duress, you are forced to enter into that contract. Maybe threat of violence or economic threat is used against you. Then in that case, you, that contract can be reshaped. Or when someone uses undue influence on you, like he has an influence over you, it might be age, it might be the fact that he's your banker or he's your lawyer, and he prompts you to enter into that contract. Such contracts are reshaped. Then when there's misrepresentation, when you misrepresent facts of the contract or of the subject of the contract, you are not being frank with the person. In that case, that contract can be initiated. When there is a mistake, mistake is not it can be mistake in terms of identity. You can mistake the person for someone and sell a product for him. You can, in that case, that contract is initiated. Mistake can be also where the subject matter of the contract is no longer in existence and parties went ahead to enter into a contract. So that kind of contract is also vitiated because the subject matter of the contract is no longer in existence. Because at the time parties were negotiating, unknown to them, the subject matter, let's say a filling station, was burned down or something. So as such, that contract will be vitiated. So then what are the things, how can we discharge a contract? When parties have entered into an agreement, how can they discharge the contract? By performance, where parties have performed their obligations in the contract, then that such contracts are set to discharge. When there's frustration, when the subject matter of the contract is no longer in existence, and when there's a fundamental breach too. Fundamental breach when you order for a phone, let's say from Jumia, you order for an iPhone and then they are supplying with HTC. That's a fundamental breach, and parties could terminate their contract by mutual agreement. What are those remedies where there is breach of contract? One of such damages. Damages are just uh, cash equivalent of what you suffered, the damages you suffered. So they are monetary compensation for what you suffered as a result of that breach. Then we have specific performance. Specific performance is when you are asking the court to ask the other party to perform his own obligation of the contract. Then we have ratification. Ratification is when the court decides to alter the contract a little. Though the court hardly does that, the court hardly alters the contract, but where the court sees the circumstances, the court will look at the circumstances of the case, where adverse injustice will not be done to any of the parties. In such a case, that contract might be rectified. Then there's what we call injunction. Injunction is stopping a party from doing a particular act. Then we have quenching marriage, where you will pay for the reasonable service you offered to somebody. When the person decides to terminate the contract and you've offered your service to a certain level, that person is supposed to pay you for that service you offered. So that's what we call quenching. You can approach the court and ask them for quenching. Rescission is when the contract is totally rescinded from up initial, from the beginning. The court will say that contract does not even exist. That contract, like if it is an illegal contract, the court will say that contract, the court can rescind such contract. Thank you very much. Come to the end of today's class. It's now time for, if you have any question, or any contribution or any comment you want to make, that is the time to do that so that we can quickly round up. If you have any question. Any question, you unmute yourself and ask your question. Somebody asking question. Sorry, is somebody talking? Is somebody asking a question? Question. So if they're absent, okay, sir.
Yeah. In the last session that we just discussed now,
Yes, sir.
this privity, is it privity of contract?
Yes, sir.
Yeah, I want to know, I want you to just recap that one for me. I didn't get it well.
Okay, when we say privity of contract, I'm just saying only parties to a contract can sue. If you're not a party to a contract, you can't sue. That's the
Okay.
general rule. But there are exceptions. Let's say
Okay.
you and Mr. A entered into a contract. The wife of Mr. A, when there's a breach of that contract, cannot sue because
Okay.
she was never a party to the contract.
Okay. To that. Okay.
But there, it's just the general rule. There are exceptions. And I said, like covenants running with land is an exception. And covenants running on land is like, it has to do more with estate covenants, where you, Mr. A, bought a land in one, a property in one estate, then you bought the property from Mr. A, and the estate developer says nobody should develop his wall or a particular building to a certain level, and you decided to erect your own to be, maybe they say it should not be more than 10 meters, then you erected your own to be 15 meters, even though you bought the property from Mr. A, which the contract is between you and Mr. A. In that case, the estate developer can sue you. So it's an exception to privity of contract.
Okay. Sorry. Thank you.
You're welcome.
But another question is that this.
Unmute your mic. Unmute your mic. Mr. Unmute your mic. Yes.
Okay. I've been hearing this one. They say in law is meant for the masses. How true is it?
Yeah, so this one you're taking me to jurisprudence. This one we can argue. We can argue. Law is meant for everybody. It's the way they go about implementing the law. We will need to talk about it. Maybe it's the implementation that is for the masses. Whereas for the law is for everybody.
But is it practicable?
The implementation,
especially in Nigeria,
is practicable. That's why I said we've gone into jurisprudence now. So this one we're talking about, if we look at the people we even copied from, are they not implementing the laws? Are people above the law? So it's all about the society. And let's go back to our customary law back then before the coming of the British. Was anybody above the law? That is to show you that it's just the matter of attitude and the governance in the country. If today a minister is punished for his wrong, or a vice president or a president, where the institutions are very strong, is it not France, is it not Israel that are convicting past presidents? In Nigeria, can you dare to say you want to convict a past president? Because the institutions are very strong. Is it not Israel that recently conducted investigation into the activities of their sitting prime minister? A police were investigating him. These are countries with strong institutions. So that these things are jurisprudence. We can talk without permission. So thank you very much. I think you don't have any question.
Yeah, thank you so much.
Thank you very much, sir.
Yeah.
So we've come to the end of today's module. I'm going to hand you over to the program coordinator, for the closing remarks. Thank you very much.
Yeah. Hello, good afternoon, lady and gentlemen, the last two standing. I hope you had a wonderful experience today. It's been quite a long day. As we explained earlier, we had to take two topics for today to be able to allow those of you who are traveling, preparing for Easter to have a free day tomorrow. and for the rest of us also to go ahead and make our own preparations for the Easter break. Right. Having said that, today for this week is the final day of the training. So we have to, that's why we had to take these two courses today. We want to, let me on behalf of the company thank our two facilitators today. The earlier one, Mr. Leo, actually, and Barrister Johanna, who have been with us since morning. The day is fast spent, so we don't want to keep you long. Previously, in the previous classes that we've had, when we end on Friday, we normally do our graduation on Saturday. We do our graduation on Saturday and do make some speeches, basically an online graduation, and then we release the certificates. We'll still follow the same pattern because statutorily it's supposed to be for 5 days. So tomorrow is a free day. Friday we'll do our graduation. It will be online graduation, and as from 12 o'clock, we should be able to provide the speeches on the WhatsApp platform, and then we'll send you your certificates a little after that. That's on Saturday. Then from that same Saturday, we'll leave this platform open for those of you who have items that you want to exhibit. You can exhibit those products, and then I will have it open until Monday next week. Monday is I think the 5th next week. You will have that platform for exhibition. But after that, we'll still leave the platform open for further communication with you guys with respect to any development to do with the Agnes loan facility. There are any clarifications, there are any issues you want to clear with us, any issue you want to take up with us, you always feel free to reach us on the platform. So it will remain open until the last is heard of this process. So having said that, let me once again thank you immensely for being a part of our day, and then to wish you a very, very merry, happy Easter, a Good Friday tomorrow, and the rest of the Holy Week until Easter Sunday and Easter Monday. Enjoy your celebrations. Thank you. Have a wonderful day ahead of you. Right. Bye-bye.